Hi, everybody, and welcome back to another week of Samfiru Tumarkin's question and answer session. My name is Aliya Virani, and I am an employment lawyer in Samfiru Tumarkin's Vancouver office. Samfiru Tumarkin is an employment law firm, which means that we specialize in all things to do with the employment relationship. So this could be, maybe you've been terminated and you've been offered a severance package. Maybe you're having some issues at work. Maybe there's been changes to the terms that you currently work under, or maybe you've been you've been laid off, or you've had a change in your pay, or some of your benefits are being taken away. Anytime you have some sort of issue with your employment relationship, we're able to help with that. And what we do every week is host these Facebook Live and YouTube sessions where we take questions from the general public and answer them for you in real time. If you leave me a comment, I'll be able to see it and provide you some instant answers to your employment law questions. So don't be shy. Please leave me a comment. I'm here for the next half hour, and I'm happy to answer any questions that you may be having relating to some things that are coming up at work. If I don't get any questions, then what I'll do is go into some of the popular topics that we've been noticing through speaking with members of the public who call us for consultations. One of those popular topics right now happens to be, we are about a year into the pandemic. A lot of companies have switched to an arrangement where their employees are working from home. And a lot of people are wondering what their employer's rights are to monitor them and to keep track of what they're doing while they work from home. So if I don't get any comments or questions from anybody that's watching, I'm just going to go into kind of like a brief overview about your rights as an employee working from home and your employer's rights to keep track of what you're doing while you have alternative working arrangements. For anybody who may be joining me right now, my name is Aliya Virani, and I'm an associate in Samfiru Tumarkin's Vancouver office, and I'm an employment lawyer, and I'm going to be here for the next half hour answering all of your questions if I see any in the comment box that have to do with your employment relationship. And I just see that there's a comment now from Janice from Facebook, who asks, if I quit and I am working from home and using my own computer, do they have the right to review my computer? All programs are web-based. So this is a fantastic question, Janice. This is something that I've been asked a lot recently. And it's understandably concerning because if you haven't already been working from home, I think a lot of, at least in BC with the new restrictions that are being rolled out, it's popular for employers to start thinking about transitioning to a work from home model. And if you haven't already, say, I think this is going to be more an issue for people who are starting new jobs in the context of the pandemic. I know it's unusual, but some people who have maybe obtained work recently, they may be asked to sign some sort of agreement where their employer will be able to look at what they're doing at home, or ask them to use something like a laptop that's provided by the company that may have some sort of software on it that monitors when somebody logs into their working programs, or when they're starting the day, ending the day, that type of thing. If you haven't already been under an agreement, or if it's not a term in your employment contract, if you have a written employment contract, this would be something that would be one of the terms when you initially started with the company. If they don't have anything in there about the employer's ability to, monitor you or what you're doing at home, or, with their ability to, give you some sort of cell phone or laptop that would have a program that's allowing them to see what you're doing, then they can't introduce that as a term of your employment once you started to work from them. That type of change would be a significant one-sided change that you have no obligation to accept. And so that would be improper. And then the second thing that I would mention about this is that, your employer is still going to be required to follow certain privacy rules. So they can't, even if you are signing on to a new contract of employment where this type of term is included, where the employer is able to surveil you from home, it's going to have some limits. And so they won't be able to monitor your out of work activity. And I think the question is like, well, if you have this app that's downloaded as part of your personal computer, how can you tell if you're working or doing something on your own time? And that's the type of thing that would be limited, that your employer would not be able to do. It's going to be less likely that they're asking you to put something on your personal laptop if you've already been working from home and force you to do this, or else say that, you're going to be terminated for cause. That would not be misconduct by an employee. If you refuse to do that, if you've already been working, you're working from home, and all of a sudden your employer asks you to put this type of app on your personal computer, that's certainly not inappropriate to refuse to do. And it certainly wouldn't rise to the level of misconduct that they could terminate you for cause for. So I think that that's going to be a relief for a lot of people that are wondering about the limits to an employer's ability to surveil them while they have these working from home arrangements. And then your follow-up question, Janice, is would they be able to review your computer before you quit? And so if it's a company computer or company laptop that they've provided, they may have, it's certainly not uncommon for me to see when an employee has been let go without cause, for example, there's usually a requirement to return the company's property. And in that case, they would be able to look at anything that's on the computer that had been done during the time that you were employed. But if it's your personal computer, then certainly they're going to have to follow privacy rules about that, and they wouldn't be able to request your personal belongings or go through them as any right that the employer would have. So there's going to be limits to that. If you haven't, I think what I can distill the main principle down into is if anybody's already been working from home and they haven't had as a term of their work from home arrangement or their original contract that their employer can keep track of what they're doing in terms of work, or if you haven't been provided, say, a company laptop where they've let you know before you started to do this that there is a program on there that's going to monitor you while you're working, then any changes that they introduce like this are just not going to be allowed. You certainly can refuse them, and it wouldn't be employee misconduct. And even if it was introduced in the beginning of your employment relationship, maybe for those who are starting a new job in the context of the pandemic when people are already working from home, there's going to be limits to what the employer can do that are subject to privacy laws. And something like reviewing your personal computer before you quit is not going to be appropriate. So I have another question from Beatrice, who asks another very appropriate pandemic-related question working with alternative work arrangements, which is, can my employer restrict our travel outside of the country in the future? So I think that as we start getting into a bit of a routine with working from home, there have been certain limits to those working from home arrangements. Some of those are improper, as we've seen with the surveillance. Some of those are a little bit more, I think, within the limits of what an employer is able to do. For example, if you are working from home and you decide to, well, why can't I maybe go somewhere else? I don't have to work from my home. Maybe I can work from a cafe. And then you take it a little bit further, and what if I go to the next city? Or what if I go, like you said, outside of the country? There is going to be limits there that are reasonable for your employer to ask you not to do. And that would look like something, perhaps you're going to a different province, or perhaps you're going to a different country. That's the type of thing where they would reasonably be able to say that their employees can't do that. And the reason why is that by virtue of you moving to a different location, say out of province or out of country, one, your employer may not be licensed to practice or operate in those areas. And so it could be a concern where they need to know, first of all, you'd want to check in with them and let them know that you're doing this. Perhaps it's not a problem. And you won't know that until you really ask to see what their policy is with respect to your working from a different location. But in general, you have to be wary about these types of things without notifying them first, because, like I said, perhaps your employer is not able to operate in that province or country. And then by moving to that different area, you could unintentionally be subject to the laws of the place that you're now working from. And so it depends on how long you're there. But, for example, you could be subject to different income tax rules. You could be subject to different employment law rules. So it can really change the character of what you're doing for them in a way that you may not have even intended. And you may have to run it by them before you make those types of changes, because they could have a lot more significant consequences than you realize simply by maybe working from, maybe you decide to go somewhere else in the same time zone, but you're down in Mexico, or say you're in a place where it doesn't restrict travel. Right now, at least in BC, you're restricted to travel inside your health region. And so perhaps this isn't something that's going to be an option for a lot of people, at least in BC right now, but maybe when the travel restrictions open up and you have been under a working from home relationship or arrangement, then you may wonder, well, how far away can I go before I am causing problems? And the answer is that you have to start being wary about this as soon as you go outside of the province, because like I said, you could have different rules that apply. Your employer may not be able to practice in those areas or operate in those areas. And it's always best to run it by them to see if they have any restrictions like this before you make that type of decision. So I have another amazing pandemic related question from Mary. These are all topics that have actually come up, not only with the people that I speak with, but there's been lots of requests for comments on, stories in the news, because these are all things that we need to be thinking about, I think, especially now as the different age groups are starting to have registration available for the vaccine. And Mary's question relates to the vaccine. She asks, can an employer treat vaccinated employees differently from non-vaccinated employees? It's a good question. And like I said, there's going to be a balance and a limit to a lot of these answers. And it's a balance between the employee's rights and the employer's obligations. And on the one hand, an employer has an obligation to provide a healthy and safe working environment for its employees. And so that may include, for example, encouraging or requesting employees to get the vaccine when possible. Now, there's going to be a limit on the other side, because the employees, perhaps not everybody wants to get vaccinated. They have the right to make that choice. And there is no law that says, at least right now, could change in the context of COVID, but there's no right of the employer to force their employees to get vaccinated. There's also going to be a limit to their ability to recommend getting the vaccination, because some people may not be able to, either because they have religious reasons not to get the vaccine, or because they have health reasons why they can't get the vaccine. And so it would certainly be improper for an employer to require an employee to get vaccinated under those circumstances. In fact, it may violate certain rights that they have under the Human Rights Code. And so they've got protections against being discriminated against if they decide not to get the vaccine and they have a reason for it that's grounded in either religious or health grounds. It's one of the protected grounds under Section 13. And so if you're treated differently because you decide not to get the vaccine and it's based in one of those reasons, that would certainly be improper. And the employer would not be able to treat those employees differently. If it is an employee who's simply choosing not to get vaccinated because they just don't feel like it, they don't trust the vaccine, you can have a variety of different reasons, and it's entirely within your right to do that. Then you have to go back to that concept that the employer has to provide a healthy and safe working environment. It still exists even for the employees who choose not to get vaccinated for reasons related to religion or disability or illness. But, the employer, in their obligation to follow work-safe rules and public health orders that have been passed down by the provincial government, may have an obligation to either separate those employees from other employees to ensure that they're following social distancing, or they may request that they be moved to an area where they limit their contact with the public because they're not vaccinated. And so they are going to be able to do that in terms of treating them differently, but treating them differently to a certain extent. Like, it's going to have to be related to their obligation to provide a healthy and safe working environment. And things like, decreasing their rate of pay or starting to, bully them or harass them because of it, that's certainly not going to be the type of change or different treatment that an employer will be allowed to do in the context of an employee deciding not to get vaccinated. Okay, so I have a question now from Tigers and from Facebook. And Tigers asks, I have a human rights claim before the commission relating to federal government employment. I have been asked to specify damages. Do you have any advice in regards to seeking monetary damages versus seeking a new accommodation? Can I ask for both? So that's a fantastic question. The Human Rights Tribunal can offer a variety of different remedies. And when they ask you to specify damages, what they're asking you to do is this. There's traditionally, you can request, damages are essentially just compensation or money that is supposed to make you whole for the legal wrong that your employer has committed against you. And in the context of the Human Rights Tribunal, you can ask for your back wages up to the date that you could ask for, say, reinstatement. You could, and then in that case, you can ask for accommodation. You can ask for an apology, a formal written apology. You can ask for your employer to have sensitivity training, and you can ask for damages for on the basis of the fact that they have been discriminatory under one of the protected grounds under the Human Rights Code, either the federal Human Rights Code or one of the provincial Human Rights Code, provides code protected grounds. And so those damages are called damages for injury to feelings, dignity, feelings, and self-respect. And that's sort of the amount of compensation that you receive simply by virtue of your employer having committed that act of discrimination against one of your protected grounds under the code. And so the type of damages that you request, or the type of remedies that you request from the tribunal, is really going to depend on what you're looking for. Some clients that I speak to, they're very interested in getting something like a written apology. Others, they're not interested in that at all. They're more, they would like to get made whole again in terms of compensation because their employers committed that act of discrimination. Others are very interested in sensitivity training. Some feel like there's going to be no saving the employer, and really the best way to go is just, a request for compensation. It depends on what you're looking for, really. If you're looking for accommodation or a return to your position, and you think that relationship is salvageable, then that's going to be a different type of remedy. It's really, I think, what the best advice I can give you in regards to seeking a remedy under your complaint under the code is what's your objective out of all of this? Are you trying to return to work? Do you want to salvage the relationship? Do you feel like you want them to acknowledge the wrong and receive sensitivity training to fix it for future employees that may be in a similar circumstance that you want to prevent from going through the experience that you went through? Are you interested in having that apology or that recognition from them? I think a lot of people that I speak to, if they had just had that apology or acknowledgement from the beginning, that would have meant a lot to them. Or are you simply, in recent decades especially, or recent decisions that have been released by the tribunal, we've seen an increase in the amount of damages or compensation that they've awarded for injury to dignity, feelings, and self-respect. And if you're interested in seeking compensation under those grounds, because especially on the basis of, we see a lot of increase in those awards on the basis of vulnerability. And so if you have certain vulnerability concerns where they have not treated you properly, especially in the face of kind of circumstances that make you a little more susceptible to harm, then certainly that would be something that I would look to seek compensation for injury to dignity, feelings, and self-respect damages. And so it depends on your objective. It depends on what you're looking for, and take some time to maybe go over what would make you feel that process is worthwhile and the reason for bringing that complaint, and that will give you a better idea on what kind of remedies that you want to seek. So I have a question from John and from YouTube, and John asks, what legally defines your job title? Is it what the employer assigns to you or what you actually do? Such answer only to the owner as opposed to answer to another employee. So I think what you're asking, John, is what's like the legal definition of an employee's job title? That's a good question. It's gonna, it is based in part on what your official title is on your, say, business card or your email signature or what you've been hired to do. Maybe it's written into your employment contract. That's certainly important. But what I would also say is worthwhile is looking at really the content and the character of what you're doing day to day. And so especially if you know that you're, the type of duties that you're doing are, say you start off as someone who's, an employee without a lot of supervisory or leadership responsibilities, and it starts to move to a different character such that you're now looking over work from another group of employees, or you have some direct reports or essentially people reporting to you, then that type of thing is going to matter in terms of, for example, why this would be important is in the context of receiving a severance entitlement. Maybe you've been terminated without cause, and by the time you were terminated, you're no longer holding, like maybe a lower level responsibility position, but at the time you're terminated, you're now, overseeing a team of 4 people, but they never bothered to update your job title. That's really going to matter. I think it's very fact specific. If it's simply that your job title has more or less remained the same, but some of the duties have expanded by the time, maybe to other types of things that don't necessarily really, there's not that clear change in the character of your employment, that's going to be harder to argue that maybe your job title's a little bit different. It's going to be very fact specific, and it depends on what you're hoping to do by having that job title be, what's the purpose of having your job title kind of characterized a certain way? Are you hoping to get a raise, or are you hoping to get, bring this to your employer to, support maybe requesting additional compensation in the context of your employment, or is it for the purpose of increasing the value of a severance package? I think what you would look at is really the content of what you're doing, and then also anything that's written that indicates that your responsibility is greater than what you've been doing. But the general presumption will be, say, if you have an employment contract that lists your title or your position or a signature or a business card, that's probably going to be the first place. And then you'd want to look a little bit deeper to see what you're actually doing on a day-to-day basis, to see if you can support characterizing yourself in maybe a supervisory or a management level role, if that's the case. And if it's clear that you have been doing management level responsibilities and it's simply that the employer never got around to updating your card or your title, then that certainly will matter, and it's going to look beyond what was written into what you were actually doing, especially if you have significant duties that you've been doing for a long period of time. So I have another question from Tim, and Tim's question, I don't know if I can read the whole question. It's just cut off a little bit at the end. So Tim, I'm going to do my best to answer most of this question. And Tim from Facebook asks, thanks for taking my time. No problem. So I want to ask you a quick question. Okay. My employer terminated me on April 14, 2021, and mentioned it as a just cause. I worked with them 15 months and 3 weeks. So just over a year and about a year and almost 2 months. They didn't give me, a year and almost, 3 months and almost a year, 3 months, almost 4 months. They didn't give you any notice period, any severance, except 4 vacation days. I was eligible for 15 vacation days and 10 care days. I was also supposed to get a bonus of $8,000 to $10,000 based on my performance for the first quarter, but they didn't pay me any as I wasn't an active employee on the 15th of April. As per the employment agreement, they're only liable to pay if the employee is active of the next month after the quarter end. What are my options here? I was wrongfully dismissed without any warning, disciplinary action from HR. So those are, that's all I can read from the comment now, but I think I have a general idea of what your question is, which is you've been terminated for cause and you worked for them for a short period of time. You've had no disciplinary record and no prior warnings from this employer. And they've also neglected to pay your bonus, which they believe is going to be something they don't need to provide based on your employment status at the time of termination under your employment agreement. But you want to know, is this legal? Have they done everything that they need to do correctly? And, probably what are your rights here? So anytime I see a termination for cause, I think it's a fantastic idea for people to get that reviewed with an employment lawyer. And the reason is this: there's actually a very, very high threshold for an employer to meet in order to terminate an employee for just cause. It needs to be a significant event, for it to be a one-time event. And if it's for something like sales performance or incompetence or absences or lateness, or, a small series of concerns, then there needs to be a system of progressive discipline that the employer follows. And so for them to summarily dismiss an employee on the basis of maybe showing up a couple times late in a week, that's not going to be appropriate. Or from, if they want to say that there's insubordination and it's just a disagreement between you and your manager that happened one time, probably not going to meet the threshold required for them to terminate you fairly for just cause. I'd need to know maybe the circumstances that they're saying that they have just cause to dismiss an employee. That's always helpful. Part of that's going to depend in part on what type of employment you had. If you have like a management level role and there's like a serious issue that came up, that is going to be a little bit different than maybe somebody who has who doesn't have that management level position, who's made the same mistake simply because there's maybe a higher degree of trust that's required, or there's a certain type of duty that's required from their management level employees, say for in a bank context, or depending on the character of the employment. But for the most part, it's going to be a determination that looks at all aspects of your relationship with your employer, including how long you've worked for them, if there's been any issues in the past, which it sounds like in your case there has not been, and really what type of problem they have and how that affects the business, if it had any effect, if it's just an interpersonal issue. And they have to make sure that they have really gone through every option possible before they've decided to terminate you for cause, because what they're essentially saying is that the employment relationship is impossible to continue. And there's a good chance that they have not met that threshold, I think is the short answer. Very, very good chance. And a lot of employers think that they have, and they haven't. It's a very popular reason to bring a wrongful dismissal complaint and succeed. With respect to your bonus, even though there's language in an employment agreement that says that you're not eligible or entitled to that bonus if you're not an active employee at the time of termination, there's some recent case law at the Supreme Court of Canada level that kind of rebuts that presumption, where you need to have very, very specific language. And even though they may have thought that they've drafted a clause in your contract that eliminates their obligation to pay you this bonus, it's very worthwhile to have that reviewed as well, because if it is an expected and integral part of your compensation, I know you've only been there for just about a year and a quarter, but if that has been something that you've been provided in the past and you kind of rely on this, and depending on things that may be written about this bonus in your correspondence with your employer, it could very well form part of your claim in your wrongful dismissal complaint if you decide to do that. And it's not uncommon for that to be something that you need to be awarded as part of your severance if it's determined that they did not have just cause to dismiss you, and any other compensation that you may request. There's a couple of different options for what you can do if you are bringing a wrongful dismissal claim on the basis of being wrongfully terminated for cause. So the short answer is that, Tim, you should get this reviewed. You should get all your documents together, a summary of what exactly happened, any correspondence that you've had. I see you've given me a little bit more details here about it being some sort of maybe interpersonal conflict and that you're an account manager. So it's very worthwhile to get this reviewed. Gather all your employment documents, including that employment agreement that says that character about your bonus, and then it's very possible that you've been wrongfully dismissed. So I see that they've got a couple more questions from YouTube, from people who are curious about a couple of different things. And I'm not sure if I'm going to have time to go through all of them. I really appreciate that. For example, Puneet, that you've left your comment. Toe tag, I think that's probably a nickname. And Eucalyptus. I don't know if I'm going to have time to go through all of your guys' questions. And so if you want to reach out to us, you can always contact us on help@employmentlawyer.ca, or you can email us at, there's a contact us form on www.stlawyers.ca. That's our website. You can find some fantastic employment law information there. And if you fill out your details in the contact us box, then we can have someone from our intake team contact you and set up a consultation. A lot of times the consultations can be free. And so that's what I'd recommend if I can't get to everything today. But so I'll just end with Eucalyptus' question, which is, can an employer ask you to leave your job and find a new one? What should an employee do? Is this legal? Sounds like that's not legal. Your employer can't ask you to resign. Resignation has to be voluntary. And if it's not, then it's a forced resignation, or if it's retaliatory in return for maybe you making some sort of complaint, then that certainly would not be legal. And And so I'd be curious to hear exactly what they are saying to you in terms of trying to get you to leave. If they're trying to force you to leave against your will, it could be, say, by virtue of making changes to the terms of your employment. That would be something like a constructive dismissal, and it would entitle you to damages and severance. And so, like I said, anybody who wants a little bit more information about what they can do and the options and the procedure, first of all, check out our website, check out pocketemploymentlawyer.ca. We've got some fantastic information there. Otherwise, you can leave your information in the contact us form, and we'd be happy to help you. We'd be happy to help you and contact you directly. Thank you, everybody, for joining me today. I'm going to be back in not next week, but the week after. And thank you for all of your wonderful